Hi, my name is Marla Neufeld. I'm a Florida reproductive attorney and former intended parent. Many people ask me when they're considering donating sperm from one party to another, does the sperm donor need his own attorney? There are many instances where when the parties approach me to learn about the legal repercussions of sperm donation in Florida, where they say, oh, he doesn't need an attorney, he understands what he's doing, or we don't need an attorney, we understand what we're committing to, or maybe can I represent everybody involved in the matter. And it's absolutely critical and the best practice as established by the American Society for Reproductive Medicine that all parties be separately represented by their own reproductive attorney. So typically the intended parents or the recipients of the sperm have an attorney, and generally they will be the one paying for a separate reproductive attorney to represent the sperm donor. This way everybody has the opportunity to have their own attorney to receive counsel on the obligations they're entering into with the sperm donation agreement. And also it provides the parties a confidential outlet to be able to speak to their attorney about any concerns, reservation, or requests that they want in the agreement that they may not feel comfortable asking each other directly. So when a sperm donor is medically and psychologically approved, at that point, the parties would engage their own attorneys. So the intended parents would get their attorney, and then they would pay for the legal fees of the sperm donor, and the parties waive any conflict by the intended parents paying for the sperm donor's attorney, even though the sperm donor's attorney's legal obligation is solely to the sperm donor. So generally speaking, the intended parent's attorney will draft the sperm donation agreement, and the sperm donor's attorney is generally the one that will review the agreement. And once the contract is finalized and fully executed by the parties, generally the intended parent's attorney would be the one sending the legal clearance letter to the fertility clinic, notifying the clinic that the contract is done, and in this instance, pursuant to Florida law, to allow the sperm donation to proceed and for the parties to move forward in giving the sample, testing it, and then ultimately using it. Now in Florida, we have a statute that governs sperm donation. It's the same statute that covers egg and embryo donation, and provided everything's clearly set out in the agreement, the statute generally provides that the genetic material donated to the intended parents or the recipient is the intended parents' in their sole custody to use as they wish. So the sperm donor gives up all parental rights to any child born from the resulted donated sperm. And conversely, the intended parents assume all rights to any child born from the donated sperm. So it's important to have a clearly drafted contract setting out the party's intent as to the sperm donation. And during your psychological evaluation, it's also critical to make sure that the parties truly understand their role, so that the sperm donor is not expecting any kind of parental rights. They can be in the child's life, but they're not going to have medical decisions, they're not going to have visitation rights. And I've seen situations where the lines seem a little blurry when they come talk to me about the parties' expectations and the role of the child's life in the future. And it's very important that for any matter to move forward, the parties understand that the donor is a non-parent, will have no parental rights, and that the intended parents will have full rights to the child that's born. If you have any questions regarding sperm donation, please feel free to call me at 954-761-2929. Thank you very much.